Beautiful people. And having a conversation with someone, it was almost unbelievable when it was told to them that the acting judge or the opposing party can prevent the jury from hearing certain things or from considering certain evidences. And somehow it just wasn't reaching that other party. Granted, the particular rule of evidence involved was not remembered at that point. But as a follow-up and potentially realizing that other people might need it, here's where it's at. You've heard situations where it's been said that, well, the acting judge or the opposing party prevented the jury from being able to hear certain things. This is what allows it to occur within the rule of evidence. Remember, whenever you are providing something for someone to consider, that thing being provided to be considered is an evidence. Rule 104 of the rules of evidence is always to apply uniformly with your particular states. Usually the verbiage are almost copy and paste. And the rules, sections, and numberings quite often the same. So if any matter in the state jurisdiction is being dealt with, then the assumption here is you know that you use the state equivalents of rule of evidence. On the federal level, you use the federal rules of evidence. But for general purposes, we're using the federal level. Rule 104, preliminary questioning. Preliminary questioning. In general, the court, in other videos we went over what court means. In short, for those who don't know, court is not the physical building. Court is whoever is sitting there as acting judge. Now, the issue of Article 3 versus magistrate is another matter. Generally speaking, they uniformly refer to as any type of acting judge as the court. The court must decide any preliminary question, meaning prior to trial, about whether a witness is qualified. And that witness can either be a physical man or woman, representative of an entity, or an objective witness such as video, audio, etc. A privilege exists or evidence is admissible. In other words, prior to the trial, aka preliminary, any type of issues raised, aka question, meaning you have to raise it. One of the ways to raise it is through judicial notices and motion to be heard, which quite often motion to be heard and judicial notices go hand in hand. The court must, a necessity, must decide any preliminary questions about whether a witness is qualified, whether a privilege exists, or whether evidence is. If a defendant in a criminal case is a witness and so requests, or if justice so requires. This last part can be very vague. And that vagueness can be based on the statute being dealt with, based on the circumstance, can be based on how well you finagle things on pen and paper. In short, C tells you that during trial by jury, the jury can be prevented, in fact, from considering an evidence. And the hearing has to have taken place to make that determination of what will be excluded from the consideration of the jury. And usually this hearing takes place whereby a regular jury, very important. The world of pen and paper, things that are said casually are not to be taken lightly, like you would speaking to someone in a restaurant on the phone with your. The complete 23-minute videos on the Patreon page. Take care. Best of luck.